I could have your attention, please, as I think we've got everybody inside. I'd like to start by thanking you for your patience. I know it took a long time to get everyone in, and I know it's warm, but I do appreciate that. My name is Ivan Holler. I'm Deputy Planning Director here in the department. With me tonight are Glenn Russell and Greg Chris. And this is a proposed scoping meeting, or a scoping meeting for the proposed Blackwater project. Before we get started, I'd like to tell you a little bit about what this meeting is, specifically what the purpose of this meeting is and what it's not. This is a scoping meeting where we receive comments related to preparation of the environmental documents. This is not a public hearing. There will be public hearings on that, but one thing that I'd like to make clear is that there is no decision that is pending now or anytime soon in the future. There will be opportunities for further public comment at public hearings, but tonight specifically is a scoping meeting, and the comments that we will receive from you all, and I hope that all of you have comment forms. Do all of you have comment forms? Okay, if you don't, we'll be happy to make those available to you. Yes, thank you. But the purpose of tonight's meeting is to receive your comments on this project. So what we're going to do is we're going to begin this meeting tonight with a brief presentation of the proposed project. And then after the presentation concludes, you'll have an opportunity to submit your comments. We can take those comments this evening. We're equipped to do that. Or if you prefer, you can mail your comments in subsequent to tonight's meeting, or email your comments in subsequent to tonight's meeting. So with that, just to kind of offer some further clarification on, again, what the purpose of the scoping meeting is, I'm going to ask Glenn Russell just to say a couple of words, and then Greg's going to make a brief presentation.
Thank you, Ivan. I want to emphasize how important this is, and also I want to talk a little bit about the overall process. What we're talking about here is a scoping meeting that is required pursuant to the California Environmental Quality Act. And we in the state of California, U.S. citizens of the state of California, are very, very lucky to have this, because in most other states, we wouldn't be here tonight allowing you this opportunity to make input. Let me talk a little bit about the process. When we look at a project which is submitted to us, we need to make a determination as to whether or not a project may have a significant effect on the environment or not. If a project may have a significant effect on the environment, an environmental impact report is required. That is the case with this project. We don't know if it can be fully mitigated or not. That is another question. So when the determination has been made that a project may have an impact on the environment, then an environmental impact report is required. The first step in that process is to have a notice of preparation published. The notice of preparation, which is one of the documents that you have here today, has been published, is available on a website, which we will show you the address for soon, and the period during which you can submit comments will end on April 27th. In addition, for certain projects of statewide importance, and this project has been determined to qualify as a project of statewide importance, we have to have a public scoping meeting, and that's what we're doing this evening. The purpose this evening is to give you the opportunity to comment. So these comments, these comment forms, whether you fill them in now and give them to us, whether you email, whether you send us a comment letter, it doesn't have to be on this form, this is just a convenient way of doing it, they will become part of the official EIR. So this is a very, very important opportunity for you to make input. However, the statements that you may make this evening, the questions that you may ask, those don't become part of the record. In a hearing, they would become part of the record. So keep that in mind, because it's very important to focus on the comments that you submit, whether you submit them now, and we want to make sure that we help you and provide you the information that will assist you in making those comments. Now let me talk about the overall process as it moves forward. We have estimated that this process, starting last December, will take perhaps 22 months, perhaps 24 months, until we get to the actual hearings. There will be a hearing here before the Planning Commission. There will be a hearing before the Board of Supervisors. Those will be opportunities for you to give testimony. Prior to that, once we have completed the draft EIR will be circulated for public review. We do not anticipate that that will take place for months because it hasn't been written yet. And this, in fact, is input that people who will be writing the EIR, it's the county's document, we will read these comments and take them into consideration. The notice of preparation includes what is called an initial study. This initial study is what we have identified so far as issues that need to be addressed in the environmental impact report. You now have an opportunity to tell us that perhaps there are other issues that need to be addressed, or that there's other information that we have not considered that we should consider. We will take that into consideration in the preparation of the environmental impact report. Once it is prepared, it will be put out for public review. How do you know about that? You will be able to drop off your comments, if you want to fill them out this evening, in a box that will be located physically outside the building. There'll be a sheriff's deputy there with the box. Also there will be a list. If you give us your name, your address, and if you have one, an email, you will then be informed of the availability of the environmental impact report and also of all hearings that will take place and any other public meetings that will take place. So if you want to be fully informed, make sure that you sign up on that list.
If we mail stuff in, do we get on the list that way also?
You can also email or mail things in and request explicitly to receive notices of the availability of environmental documents and all public hearings. That you also can do. So, and in addition, if you send in comments at other times, they become part of the record, but they don't become actually bound as part of the EIR. Comments that are submitted during the notice of preparation period and then the 45-day actual public review period, those end up becoming actual formal inserts in the EIR, and when the notice of, when the EIR in fact is put out for public review, those comments require formal responses. These comments will not require formal responses, but they will be taken into consideration in the preparation of the EIR. So then when you see the EIR, if you go, look, you didn't get it, then you could make the comment again, and then it would be required to be formally responded to. So I hope that we focus this evening on the importance of making comments during the notice of preparation period. We're going to have a brief presentation by Greg Kriz, the current project manager and planner. And following that, if there are things that we can do to assist you in making comments at this point, we're happy to do so. However, this is not an opportunity, as we mentioned, to provide testimony, and we're not in a position to engage in public debate for a number of reasons, not the least of which is the county has not established a position on this project. Whether the county feels this project should be approved will be a decision made by the Board of Supervisors far in the future, and we are not in a position to say one way or the other what that decision may be. So now, having said that, I'd like to introduce Greg Kriz, who is going to give you some additional information.
Then we'll get that going here. The first two slides I'm going to go through is going to be a reiteration or summation of what Ivan and Glenn just did, so I'll run through them briefly before I get to the fact sheet and just a summary on the project. We're holding this meeting tonight because it was determined during scoping of the project that it qualified as a area-wide, statewide, or regional-wide potential significant impact. And skip to the next one. What is the purpose of the meeting basically is to take your written comments. It's not for open verbal discussion or oral hearing. And again, as Ivan said, this is just the first time that we're going to be taking your comments down on the project, and there will be other hearings towards the end if the project proceeds along those lines. Again, Glenn did tell you at any point in time during the project you can submit comments to the county and they'll become part of the project file. Next. Just a basic flow chart for CEQA. The point on this one is not to have you read the fine print. You can Google this online and go through it if you want. Let's hit the next one. Basically, we're at this point in the process. And it looks like it's about halfway done, but there's still considerable work that needs to be done. We've had the application submitted, we've scoped the project and looked at some of the initial studies, as we call them. This is where we've identified if there's potential impacts and they have to do an extended study. So the step that we're at here is we've determined that an EIR is necessary and we've put it out for public review with a notice of preparation, and we're having this meeting tonight. So next slide. Everyone, I hope everyone, when you came in, you would have gotten a copy of the notice of preparation, an initial study, a fact sheet, and then a comment sheet. The first two I just went over, they are also available online, and they're now at the library out in the Pro as well if you live in the area and you'd like to view the complete package. But basically the project as it's submitted is a major use permit, a rezone, and an agricultural permit. The major use permit is for a law enforcement and military training facility covering, and the exhibit over here, and I'll pull one up in just a second, is to cover 3 parcels totaling approximately 709 acres, have an impact footprint of about 220 acres. And then there's a 4th parcel that's being looked at for potential mitigation, which in the fact sheet is listed then as total acreage of 824 acres. As part of the development process with the use permit, the project will involve both administration buildings, bunkhouses, cafeteria, driving track, shooting ranges, and then the administration buildings next to a helicopter pad, as well as 2 residences on the property. There are other buildings and structures that will be part of tactical operations and live fire training, both for law enforcement and for fire department officials. The rezone portion of the project, the site is situated within an A72 zoning designation, and they have a special area A designator, which means that it is within a county agricultural preserve. So both the rezone and the agricultural permit have been submitted in order to, 1, remove the A designator, and 2, to remove the county ag preserve designation. What we've looked at here with the notice of preparation that's gone out is we've tried to identify all significant issues on the project that are either potentially significant at this point, meaning we don't have enough information to formally answer those questions, or that we're looking at possibly less than significant if mitigation is incorporated. And it's kind of, you don't need to skip to the next one. I'm just going to run down through the list. What we've looked at potentially as significant is aesthetics, agricultural resources, air quality, biological resources, cultural resources, geological resources, hazards and hazardous materials, hydrology and water quality, land use and planning, noise, transportation, public utilities and service systems, and then the final summation and initial study, which is the mandatory findings of significance. The things that we have eliminated but will be covered in all of the environmental documents relate to mineral resources, population and housing, public services, and recreation. Those last 4 there were not determined to be a significant effect with the development of this project site. And just to sum it up, again, we have a box outside for any of the comments that you have on the project that we'll incorporate into our file and the document. And if you have any additional information, my contact material is both on all of these documents and on the web. So the next slide, it's not to scale at all. It's kind of been stretched and distorted in order to fit it onto the slide, is the proposed project. Again, that should be the 3rd or 4th page in the document that you have in front of you. And if you need additional information, the county DPLU website, that's the first one up there, can provide you access to many other resources. And the second link is the actual link to the documents that are available online at this time.
Could you repeat that? We can't see it back here.
So that's any.
No,
top link is just a link to the department's website, and it has access to a lot of different resources that county staff can use that are available to the public. The last link is direct access to the documents that are on public review at this time.
Is the link listed anywhere in this packet, so I don't have to write it down, or is it?
No, it's not.
Could you leave it out there for a second?
You can do.
That's pretty much the brief presentation that we had prepared for all of you. We are prepared to now, if you have comments at any point in time, you can go ahead and submit those. As Glenn and Greg said earlier, it doesn't have to be tonight. You can do that via email. You can do that by mailing those to us. And you also heard about how to get on a list to be notified about any future actions related to this particular project. If all of you, or any of you, I should say, have questions about how to fill out make a comment related to scoping, we'd be happy to try to answer those. But essentially, this is the conclusion of our formal presentation. So you can certainly, if you feel that you have enough information, you're certainly free to go. You won't miss anything else. And we'll be able to be here for a little bit and respond to some questions. And I'll go to you first, ma'am.
Yeah. Greg?
Yes.
You mentioned that there were like 4 areas that you've already determined were not going to be impacting other population. Is your determination available for review anywhere online or otherwise?
Basically, the initial study that's out, it's a draft initial study, but the comments that are supplied in there, it will still be analyzed in the environmental impact report. But the responses that are in the initial study that everyone has is the current understanding on the project.
There was another, I saw another hand. Oh, yes.
I had 3 little questions. One was the sale of the land, and I would like to know how much was paid.
That's not something that the county is involved with. That's a private matter that the county doesn't have any
Do
information
you
on.
know how long ago that sale was made?
Again, that's the same type of issue. We're not involved in the sale or transfer of land.
Well, the land was purchased for the purpose of this. I assume.
We do not have that information, I guess is the right answer. I understand that you'd like to know the question, you'd like to know that, but we don't have the information.
Then the third one is about the permit. Has that been applied for yet to change the zoning?
Yes, the application was initially submitted in November and was resubmitted December 20th, 2006.
I'm going to go, ma'am, to the lady just behind you, and then in the back after that.
You were talking about your project being on a total 826 acres, but you're just talking 207 now. Do they have to come forward again for another major use permit if they want to expand that project from 220 to encompass their entire 826?
Their use permit will encompass the 709 acres as identified. So there will be 220 acres of development footprint. That's an approximate right now. It hasn't been formally submitted because we've asked for a preliminary grading plan and other revisions.
So you're asking for 709 acres to be under this major use permit?
Correct.
In the back.
Hi, my name is Jeanette Hartman, and I chair the Land Use Committee of the Sierra Club. And I have a procedural question. This property is designated as an agricultural preserve under the 2020 general plan. Is that right?
Correct.
And so
Current general plan.
the current general plan. Okay. And my question is, what's the point of designating something as an agricultural preserve if you're going to entertain applications to change it? It's like having a budget that you don't stick to.
The agricultural preserve designations in the county were established in the early 1970s. The intent in the East County, North County was to facilitate landowners entering into Williamson Act contracts with the state. So an agricultural preserve itself, that designation does not preclude or limit any of the allowable uses under the current zoning. It was simply put on there to facilitate property owners entering into Williams and F contracts.
And also, I think I can speak to that a little bit more. The policy issue that you identify is a significant policy issue. And so it is correct to answer the question. The answer at this point is they can ask to have it removed. And should it be removed? Well, that's another question entirely.
Thank you.
I'm going to go in the very back.
My name is Jeffrey Smith. I'm with Wilderness for All, coalition of groups working to pass Senator Boxer's California Wild Heritage Wilderness Act. A number of wilderness areas in the vicinity, including the Hauser Wilderness just north of this proposal. My question is about the planning group. I understand there was a vote by the planning group. Two questions. Number one is, can that vote be reconsidered, or will it be reconsidered at any point? Because I understand there was a question of notice, proper notice. And number two, what does the vote or the decision of a planning group, what bearing does that have on future decisions relative to this project?
I'll answer that. The planning groups are really very much independent advisory bodies to the county. So the county is not involved in setting their agendas or validating their votes or any of that. We look at their votes as advisory. They have to follow rules, but if they don't ever vote again, then the county will look at the record that exists and take it as appropriate as advisement. They could vote again. That's really up to them. The main point I want to make is that many people feel that the planning groups are a formal part of the decision process, and they're really not, in the sense that they have a vote which is binding. They're strictly an advisory vote, and they operate very independently in terms of when they vote, what they vote on, and how they vote.
Yes, ma'am.
Sorry, please be so. In regards to the planning group, what specifically did they vote on? Did they vote to allow, to essentially recommend to the county to initiate the processing of the permit? Is that what they voted on? Because that's normal in planning groups. I was a planning group member for 10 years.
I think that
What
would be
did
a
they
specific
vote on?
question for the planning group. The information that I'm aware of is that they were voting on the concept of the project.
Okay, simply project concept. So you have not been told by the Potrero Planning Group that they will support this project.
Other than what communication?
Okay, I'm just trying to find out what the
Let me
what the
answer.
specific.
Let me answer that.
For us, someone?
Other than we take whatever written communication that we receive, planning groups take meetings of their meetings and then transmit that to us. So whatever action that they took, that would be transmitted to us in writing. I can't specifically give you a better answer than what Greg just did.
The actual motion was, et cetera. And I have a second question, and that is, have you checked to make sure that every individual property owner who is a portion of this project has agreed to the processing of this application and gotten written permission for the processing of this application on their property?
So the
Because that's a
property owners
portion of your
adjacent to the
policy.
property have been notified when the application was submitted. And in addition, I believe I extended the range out to include
What
well
I'm
over
talking
100
about is
property
people
owners.
who own the property itself that are under proposal. Have you checked to make
Unless
sure that
there's-
they have permission?
Well, we certainly will.
Please do.
I'm going to go right here now.
Yeah, I heard on the program these days this morning, the planning group chairman say that the planning group's approval was contingent on a noise test. And it describes guns, but it doesn't describe a helicopter. Is the helicopter going to be included in the noise? Oh, racetrack.
You know, you have these are all very good questions, but again, they're probably best directed to the planning group because that's kind of their business. So if you're asking,
Well, why is it here if the planning group hasn't finished their job?
no, the planning group can provide advisory votes at any time during the process, and they.
Contingent vote is what I understand, so I don't understand where
Okay.
the process is, where's the
Well,
policy?
maybe they gave us a contingent vote.
But our process, I can pull the slide back up. Our process, we notice the notice of preparation that's out for public review. We've gone through all the significant areas in CEQA, identified what studies that need to be accomplished. So specifically on your question, the noise study will be addressing those types of issues. If you want to make a formal comment to that effect, please ensure that the noise study covers both the helicopter, operational noise, shooting range noise. That would be welcome as well.
Can you just clarify this due process question for me? If you put the chart back up, if it turns out that it fails the noise test and the planning group should reconsider, can the planning group go back? I don't understand how you can have a halfway vote and continue on.
The answer to your
without the
question,
test.
the answer to your question is yes. The planning group could do that.
If the planning group, and also in answer to your question, the planning group doesn't have to vote on anything if they don't want to. It's not required. In other words, they could choose not to vote ever. And when that then project goes to a decision maker for hearing, that would be taken into consideration. It's not required.
I had one up here before I'll go back to you.
I was told that the scoping meeting was going to be held in Potrero itself, and I wondered how come that venue changed, and if the next scoping meeting, or if there is another scoping meeting, is going to be held in the Potrero environment.
The initial intention was to hold the meeting out there. We deemed that there would be a much larger facility to have it here.
So what changed this decision?
It's a larger facility to hold the meeting here. There's been a lot of interest in the project.
I'm gonna go over. Did you still have a question, sir?
Yeah, I was curious. It's a procedural thing, and Glenn, I have to thank you for your call yesterday. It was very helpful in clarifying a lot of the situation that's going on here today. One of the things I had a question about, though, is if the planning commission over here is just advisory, could Blackwater simply have gone directly to you folks and put the proposal without going to an advisory board? Could they have just bypassed the
Well, we transmit information back to community planning groups as a part of our process. I think what Glenn is alluding to is he's saying, even though we would do that, if a planning group were to choose not to place an item on their agenda, that's their decision. But we do provide that information to them.
And could Blackwater have chosen not to go to the planning group? That's up to them. But upon receipt of the application, we send all the application materials to the planning group, and they can do with it what they would like.
Yes, sir.
Just to follow up on that question, would this project have gone ahead without the planning group's vote?
Yes.
Yes, absolutely.
The
The
application
processing of the application?
Correct.
Okay, if they didn't vote, how would people in the community know that this was even going on? If you only notify the immediate property owners, and I know you said you went further, but there's a whole big community out there, and how would people even hear about it?
Could you imagine the community not hearing about this project? Well, you are here and you're very pleased that you're here. And the word is out.
Did you have a follow-up,
I
sir?
had one more question. How does this project fit under the A72 designation?
Under the current zone, this project would fit as a major impact utility. And it's a major impact utility and services. And so it requires a major use permit.
If you look at our zoning ordinance, which is the ordinance which requires major use permits, it includes definitions of use types, commercial, civic, etc. This one is classified as a major impact service and utility. If you then look at what the A72 zone allows, certain things are allowed by right, certain things are allowed with minor use permits, and a major impact service utility is allowed in an A72 zone with a major use permit. That's what our zoning ordinance says.
But this is a limited liability corporation that's in business for profit. How does that fit under agricultural designations? It's not a farm.
Well, They,
Not a Boy Scout camp.
Now,
I don't
again,
understand
this-
how the designations would allow that.
that you again are addressing an interesting policy issue, but they can ask, and they have asked, and that's the best information I can give you right now. Now, your opinion, sir, is very important, but we're not in a position to debate that opinion with you here today.
What would be a good example of something that would fit under these designations?
Chicken ranch.
Major impact utility or whatever you said. Well, there could be an example.
Well, there are many examples.
Roads, water.
There are a great number of different examples. It could be telecommunications facilities. There could be agricultural, large commercial. I don't have my zoning ordinance here, but if there's a long list of different kinds of utilities that could go in there. They could go with, there could be a mining operation. There could be all sorts of things.
It seems like a large commercial enterprise, a business, to make money.
And just to be clear, what
It's
we...
not a farm.
It is
Well,
a chicken farm.
Just to be clear, here's the process. I think what Glenn is saying is that with the zone and a combination of a use permit, there are a number of different uses that can occur on that property that you would not think of as traditional agricultural uses. That is what our zoning ordinance says. So I understand your question, but those are the rules as they exist today. And I'd encourage you to include those things in your comments.
How long have these designations been in place? Is this a new
Years.
change?
No, years. I'm gonna go to this gentleman right here.
Yeah, I'm kind of curious. I see a lot of faces here. I live in Potrero, and I see a lot of faces here I don't recognize. So I'm just curious as to how many people actually live in Potrero.
There you go.
You see, there's a whole lot of people that don't.
Most of them.
I don't exactly remember who's next, but I'm gonna go to this gentleman right here.
How and why did it get fast track status?
There's been a lot of discussion about that. Let me try to clarify this fast track quote unquote status. The County of San Diego has engaged in a project where we're calling it, because we're government, we put acronyms on everything. We're calling it BPR, which is Business Process Reengineering. What we're attempting to do is to take all projects that come into our shop and try to process those as quickly as possible, but still responding to all of the concerns and still maintaining our quality. So that's just a service that we want to try to provide to all of our customers. This particular application is one of the first that is following that process, but all subsequent applications will follow that process as well. So this particular application is being treated no differently than anyone else that comes in under our attempt to try to streamline that. I don't remember who's next. I'll go use it.
Just kind of for Glenn. Glenn, if in the final analysis of the ER, one would find that there are significant and unmitigable impacts, is this the notion or what this project accomplishes, this training, would it be considered enough of a public benefit to have overriding finding?
Let me clarify that for the audience. The question was, if in fact the final analysis determines that there are significant and unmitigable impacts, would this project be appropriate for overriding findings? What he's referring to is a portion of the law of the California Environmental Quality Act that says that if a decision-making body decides that the value of a project outweighs the impacts, even if they're not fully mitigated, they can still approve the project if they adopt overriding findings. Now, that is part of the law as to whether this project will have unmitigable impacts and whether those unmitigable impacts would be subject to overriding findings. I have no idea.
Let me go to you.
What can stop this project? Like.
Now, Now that the project application has been filed, as long as the applicant wants to continue processing that project, we are obligated to take it to the hearing bodies. So if they want to continue processing the application, ultimately it is the hearing bodies, the decision makers, which we are not. We are just processing the application. It's the decision makers who make that decision.
Board of Supervisors?
Ultimately.
Ultimately, the Board of Supervisors.
So if they vote on it and say no, then we win?
If they vote on it, they can approve the project or deny the project.
And that's the end of it if they deny it?
They are the ultimate decision makers.
I don't know who is next. Let me go to you, ma'am, and then we already went to you once, but let's go to you next.
My name is Luisa Wildy. I'm a resident of Potrero. I live a mile and a half from the project. Is there any way you can tell me if the owner of the property has a right to sell the property? Is it part of the law that he can have the freedom to sell it?
I don't know the answer.
John, not in our purview. Yes, sir.
You had a comment earlier whether Blackwater was in the neighborhood, and they definitely are in the neighborhood in Potrero, schmoozing the neighbors. Now, my real question is, the language in here talks about how little of this valley they're going to use. And this overlay really shows they're going to use all the usable valley that we see right there. We talk about cattle ranching. I don't know how that's going to take place. And are you going to monitor it? I mean, you're giving up that whole valley, and there are not very many of those left.
I guess I'm not quite clear on are we going to monitor?
It says you're going to continue with cattle ranching.
Oh, I see what your question is.
Raise mountain goats, cattle psychology.
This has been reduced down to 8.5 and 11 just to make it for an ease of making 200 copies tonight in anticipation of a lot of people.
Thank you.
So again, third or fourth page in the package, you're entering the project site. There's limited development with 2 residences here, an administration building, and helipad. Again, as I'm going through this, this is subject to change. We've asked for revisions, we've asked for items to be addressed. So what you're seeing right now could be the final copy that gets taken forward to the approval bodies, but there may be revisions. Development then is proposed with a driving track in this area, and then the administration buildings, tactical areas, and shooting ranges extending up here. So this whole portion of the valley, from north to south, running right through the site, is actually going to be preserved in open space. That's proposed right now.
That's for the cattle?
Okay, I'm sorry, did you have a follow-up? I didn't hear.
Well, you also said you had the meeting here so that it was a bigger facility. Less than half the people got inside.
Oh, no, everyone's
Actually,
here.
everyone that was in line outside came in.
That's true. Everyone is inside.
Yeah, I take that back.
I'm going to go to, I want to go to folks that haven't had an opportunity. I'm going to go to this gentleman right here.
I'm Jim Pugh from the San Diego Audubon Society. I noticed looking at the initial study that it says that there's no impacts to federally protected wetlands. But does that mean that there are impacts to state protected wetlands and county protected wetlands that aren't delineated federal? You know, the federal requirement is more rigorous than others, so that's kind of a strange, so it says there's no impacts overall because there's no impact to federal land, and that doesn't make sense to me.
The biological resources report has been, there's revisions that have been requested to it. So it's draft at this point, so I wouldn't be able to tell you whether or not there's full impacts to the state wetlands. That'll have to be a determination made with the consultant and with the state fish and game officials.
Will that be in the final, in the draft EIR?
Yes, it will be analyzed.
And that would be a very appropriate comment to make.
Jim, that's what I was going to say.
And then another question is, it talks under biological resources that the 560 acres will be set aside as a conservation easement, but it doesn't say, and I hope that the allowed uses in the conservation easement are well specified, because it either could be suitable mitigation or it could be crap, depending on how it goes. And then under hydrology and water quality, it says that the Jura, the Sioux Sump, and the what was it, runoff management, one of the other plans will provide that there won't be any water quality impact. except for this is in the watershed of the Tijuana River and has a TMDL for lead, so there can be, it has to be a zero discharge for lead. And there'll be an awful lot of lead involved in this project, so I don't think that the Jurup and the Suisun are sufficient to say that there won't be a significant water quality impact. So I hope you'll do some more analysis than just refer to the document. Okay, thank you.
Again, those
Just to add on those comments, again, there are other regulatory agencies that will be involved looking at this project, including the Forest Service, Bureau of Land Management, Fish and Wildlife Service, Fish and Game, Regional Water Quality Control Board, and in some cases with the aspect of lead and firing ranges, you will have OSHA involved.
But it's difficult when the IS states that there won't be an impact because of certain actions, when we know that all these other actions exist, and the IS sort of implies that you're not going to be doing all those.
And Jim, those are exactly the kind of comments that I would hope. I want to go to someone who hasn't participated yet. Oh, okay, and then I'm going to go to this gentleman in the back next.
Okay, hi. Raymond Lutz with Citizens Oversight. I've got really two things. First of all, we found out that there was an attorney who was employed by Blackwater who had taken up a job within the planning department. And I'm wondering if anyone else has been on the payroll of Blackwater that's involved in this project at all, and if that can be disclosed.
Although not an EIR question, it deserves an answer. Lori Spar worked for us for several years as an environmental planner, and then she decided, I think I want to go be a lawyer. So she went off to be a lawyer, and she worked for a firm that is in fact representing Blackwater. I don't know the extent to which she had very much to do with the project, but she decided she didn't want to do law anymore, that she wanted to come back and do planning. So she came back, she works for us now, and when we found that that she had worked for the firm that was representing Blackwater, we said, oh my gosh, there could be an appearance of a conflict of interest there. we immediately removed her from the project. She has absolutely nothing to do with the project, nor will she have as long as the project is with us.
Nor does anyone else.
And there's no one else.
Okay. One more thing, if you don't mind. One of the jobs we do as Citizens Oversight is to encourage public involvement in these meetings. I'm really concerned about the way you've denigrated the impact or the involvement of the community planning groups, because these are elected officials, and indeed they're unpaid, but they're volunteers and they're trying to do a good job. A lot of the public comes in to voice their concerns and have comments and the like, and apparently you guys really don't care what the planning groups say. Maybe you didn't come out to the planning group and talk to them. I did attend a meeting there, as the people know. I've been trying to get another meeting scheduled for this month, which they canceled. This lends the appearance that the planning group doesn't care about citizen involvement, and indeed, your attitude here is that you don't care either. You don't take it into consideration, and in fact, it sounds like you haven't even read any of the stuff from them yet, because you didn't know what their decision was. So I'm really concerned about this, how this department is just casting aside all the work that citizens come in and they talk and they try to, if they can. In this case, most of the citizens didn't know it was being processed because it wasn't advertising anything except for the Potrero hotline, which used to be owned by the chair. And so it looks like this thing has been not put into the big things. And no, I disagree with the gentleman who says that no one should be here that doesn't live in Potrero. This is next to the Cleveland National Forest, which we all have an interest in. So this thing of making the planning group so you don't care, they're not going to have a meeting, and you don't care if they vote on anything or not, the vote doesn't matter. Why does this happen in a democracy? These people are elected and they should do their job.
It's not fair. You said you already spoke. He is the one who made comments?
Chance to talk.
You made a comment. I asked a question.
Let me respond, please. I would like to respond to that.
Yeah.
And I'd like to clarify how we handle planning group or sponsor group comments. By the way, I would strongly disagree with your characterization that you just offered. We certainly consider what a planning group submits to us in terms of the recommendation and the actions that they take on this project or any other project. They do function in an advisory capacity. I think what Glenn was saying is that we, as the Department of Planning and Land Use, are not bound by their vote. They function in an advisory capacity, but we consider very strongly what their comments are. At this early stage, the comments or recommendation from a planning group is very early. The project, as it moves along, will go back, and they have other opportunities to make formal recommendations to us. So I want to make sure that you're clear on that we don't just out of hand dismiss their comments. That's not indeed the case. I'm going to go to this gentleman right here. I believe that, yes, sir. You were.
Just a second. As far as just two other items, the letter from the community planning group is not part of the file, and I have not had a chance to read it because I do not have it as part of the file. And on the second, because we're implementing the business process reengineering or BPR process that Ivan spoke about, one of the things we're trying to do is get staff more involved in the initial stages on a project. And so two of us from the county did go out and attend a meeting with the planning group.
Thank you very much.
Let's go back to this gentleman here.
I saw you there when.
But what I'd like to do, I know that you all have been here for a while. I want to try to answer as many of your questions as we can, but on the other hand, I'm sensitive to your time. So I'd like to go maybe for another 15 minutes or so, and hopefully we can take care of your questions, and we'll start with you, and thanks for your
I
patience.
just wanted it to be clarified whether Blackwater actually owns the property or not, or what.
It's in escrow.
Again, we don't work as far as who owns the property. If they have entitlement agreements to process an application, we take it in and we look at that type of information. So they don't necessarily have to own it or not own it at this point in time. So I can't tell you if they own it or
They don't
not.
have to be paying property taxes or even be a citizen of this county in order to use your resources?
They pay for our resources when they submit their application material. So every hour that we spend on the project is charged to the applicant.
And let me tell you what's not an unusual scenario. Anytime that we get a development project of any kind in some cases, the proposed developer might own that land. In other cases, they might have tied it up somehow via some sort of option agreement. So it's not an uncommon scenario. And we really don't look or sometimes are aware at one or the other.
Thank you.
I want to go to the folks that I haven't got to before. I don't think I've got you. Let me do you next, and I'll go Mim in the purple. Over here? Okay.
Yeah. Miriam Raftery with the East County California newspaper. My question is regarding the planning process under these new streamlined procedures. I've seen documents indicating that the county planners or representatives from your department have been meeting privately with Blackwater representatives, their lawyers, their lobbyists, their officers, without the public present since at least July of last year. However, I know when I talked with one of you gentlemen this week, you told me the public could come meet with you, all they had to do was call. But I've talked with citizens of Potrero, including a former planner, who tell me that when they called this office, they were told that they could not meet with you unless representatives of Blackwater were also present. And many citizens have said they feel rather intimidated because it's because of what the company does and so forth. If they did not, they felt that if Blackwater can meet with the county, if a developer could meet with their county officials, that the people who elected, representatives here ought to be able to meet with the county officials as well, without the developer being present.
Let me respond to the question about have we met with representatives from the developer. The answer is undoubtedly yes, which is absolutely the way that we work when a developer submits an application of any kind to us. We, by necessity, have to sit down and work with them. That's very, very common, happens all the time, nothing unusual about that. We have conversations with applicants as a routine course of business. And just so you know, we charge applicants for staff time. So when staff meets with an applicant, they get billed for that. That's not free, that's not a taxpayer item, that's the applicant that pays that. So that's just a standard way that we process applications of any kind.
Thank you.
What about the citizens being able to meet?
Right.
Yeah.
Can you
Answer all
answer
the
your
questions
question?
without Blackwater.
If, you know, I'm going to have to ask Glenn how we handle that. I know that in some cases, we certainly will meet with representatives from a community over a particular issue. But the reason I said that we bill applicants is because that's the way we cover for staff time. And I would, I want to ask Glenn how we might handle that if someone comes in. You know, I certainly wouldn't want to have to be in a position where he says, well, ma'am, we'd be happy to meet with you, but we're going to have to charge the way we do an applicant. But so that's kind of the concern, and it's why I mentioned how we handle the project.
Let's hear from Glenn.
Yeah, can I ask for your input on that?
Sure. We will be happy to meet with the public when people come to look at files at the counter. By the way, the files on the project are public information. You can come, look at the files. If you have questions, we'll sit down with you. We'll meet. There's no problem.
There you go. I don't know where, sir, you've had your hand up for quite a while.
3 questions. The county is the lead agency for processing under CEQA. Is this project in any way, shape, or form subject to any federal agency review or approval such that it could be subject to NEPA as well?
No, sir.
Okay, so there's no federal government agency.
It may require federal permits, but not a NEPA process.
So the federal permits that might be required would be non-discretionary?
No, they would be permits from, what federal permits is this?
Actually, Army Corps of Engineers.
Army Corps of Engineers, but...
And then permits issued through the Regional Water Quality Control Board that are generally under the domain of the EPA.
But that does not trigger NEPA. This project is a project being paid for by private funds. It's a CEQA project, not a NEPA project. If it was a public project, then it would be NEPA, but this is not a NEPA project.
Responding to an earlier question, it was noted that the county's general plan currently includes the agricultural reserve designation. And the answer was yes, under the current general plan, ... Does that mean there is now in consideration an amendment of the county general plan that would change that?
I can answer that question. The county are in the process, have been for a while, of updating our general plan. With that document, in fact, we're beginning to prepare an environmental document for that. It's a little too soon to say how we might deal with those, but in any event, that is not yet an official document or adopted, so we wouldn't be able to rely on it.
Just to be clear, though, it has not been discussed as a part of that county general plan update to remove the agricultural reserve designation on this property?
Again, what we'll likely do is make sure that where a preserve is located, that there's a contract, a Williamson Act contract that's physically located with that. That was the original intent. And in some cases, they don't have that, and so that preserve designation, the benefit of that was never realized.
I think what I hear you saying is that it was mentioned earlier that there is a Williamson contract currently on this property, or a portion of this property?
I don't believe so.
In 1988, the owner previous to the current owner filed to have the application of the Williamson Act contract removed, and that was done in 1998.
But the county general plan agricultural reserve designation still exists on the property under the current general plan.
That's correct.
So will the removal of that designation and the consequences related thereto be covered in the EIR that's being done for this project?
Absolutely.
Correct.
Okay.
I'm going to go, here's what I'm going to do. I'm going to go to this gentleman, then I'm going to go to you right here.
Relative proximity of
this project to the Pacific Crest Trail. I don't know exactly what, as the crow flies, would be, but it's not insignificant, particularly the potential noise carryover down Hauser Canyon where the PCT crosses that area. This is one of our two classic trails in this country, the Appalachian Trail, the PCT, which is a national scenic trail. Would that not establish arguably a federal nexus, and should not the Forest Service engage as to the impact there?
The impact that you suggest, it should be one that's looked at, but that does not establish a federal nexus.
I can address the gentleman's problem.
Well, let me go to this gentleman right here first.
So it says there's sensitive wildlife. So what's going to happen to them? Are you just going to build over them? Are you going to move them? You're destroying their habitat.
Under CEQA, the impacts to native habitat and biological resources have to be mitigated, and so that's being addressed in a biological resources report, including on-site preservation. That hasn't been fully analyzed to determine whether or not everything's going to be met on-site or if it would require off-site mitigation as well. Basically, if an applicant or a developer working on a piece of land has a suitable portion of that property that can be preserved on-site to offset whatever development impacts they have, we call that on-site. An example for off-site may be a 2 or 3 acre parcel that they're going to split into residential pads, and it represents maybe infill, and we may determine that it would be more suitable to mitigate for those biological impacts in a mitigation bank or in a more suitable larger preserve area, and so we call that offsite.
Does that mean they move the eagles out of the area?
That's more of a specific question. As far as eagles, the raptor foraging and the eagle issue is being addressed in the biological resources report.
The eagles are on the property.
The mitigation would have to match whatever the impact was.
But then,
Let's keep that. That's a good comment though for the CEQA document. I'm going to go in the back next, and then I'll get to you.
I wanted to ask you the cost for the EIR and all of these preparatory materials. Who pays for these costs and all of this time and people here?
The applicant pays those costs.
All of it.
Also, the police officers and the undercover police officers, they pay for them too? Because I've never seen so many.
That's a good question, and this is a little bit unusual for us. So I'm going to have to probably get back to you on the answer.
Okay.
I'd be happy to do that.
It's amazing.
I'm going to go to this, and in the interest of trying to get to as many of you as we can, because I know it's warm and it's getting late, I'm going to go to this lady right here, and then have I got to you before, ma'am? Okay, I'll get you next.
One event I don't see addressed is the fire risk. The nature of Blackwell's business, you're going to have live ammo out there, a racetrack, helicopter. It seems like an extreme fire danger with limited firefighting resources out there. So how's that going to be addressed in the EIR?
I hope that...
I think that's an extremely important issue. I don't see it.
So do I, and I think that that's a very appropriate comment for you to offer in that regards, to make sure that it is.
Great.
Yes, ma'am, I'll go to you next. And then you, sir, and I'll get to you next.
First, just out of curiosity, are there any representatives of Blackwater here tonight?
Thank you.
As far as, you spoke that said that this was one of the first projects to come in under this new streamlined plan, the re-engineering for the planning and all that type of thing. And you're serving your customers. Do I read this right, that your customers being developers? Excuse me. Seems to me that all that does is cut down the amount of time. First off, it cuts off public comment, cuts out the amount of time for researching environmental problems and any other problems that might come up pertaining to the public and the city and, you know, the public's interest.
Streamline, those are good questions. Let me.
And I don't recall voting for anything like that. I don't even recall hearing about it.
Let me answer your question. Those are valid questions and comments. Streamline processing doesn't mean shortcut. Doesn't mean that we cut out your opportunity for public comment at any point in the process. It means we try to be as efficient as we can in working with our customers, not unlike any business would try to do in working with their customers. Our customers are applicants. You are constituents, however, and have a voice in the process. So we want to be as efficient in working with our customers, but that doesn't cut you out of the process, and we don't and won't shortcut your opportunity to provide public comments. Let me go in the back.
Is there some way I can find out the difference between the two processes?
There are certain, well, now that, is it on the website somewhere, Glenn?
Yes, there is a lot of information about the business process reengineering on the website, and which we had up there. And if you have additional questions.
And just so you know, there are statutory comment periods that don't change, regardless of which process. Those remain the same. Okay? Yes, sir, in the back.
It says that it's going to be a police and military training outfit. Is that contract, has that already been made? Is that a done deal? Do we know nothing of it? Because we know they don't do that. We're told that they train other forms of training, but to hear this, it'd be kind of comfortable to know that that's already been done, because that's what we keep hearing. The reason, and you read it in the newspaper, and it's on here, that the military and the San Diego Police Department and Fire Department's going to be trained there.
They've asked, as far as we know, they've asked for a permit to do those things, but I have no information for you about whether they've established any contractual arrangements with any entities.
It shouldn't be on here then, saying that, because it's not true.
But
it hasn't happened yet. That's what they say they're going for.
It's a proposal. It's a proposal. So that is what they're proposing.
It's not true. And see, the two get intermixed between what's our government and then what's private industry, and it kind of like blurs. My second question was, what is going to happen to the Native American, all the artifacts, which are all over the mountain, and they're very sacred, this very sacred, special place. Would they all be gathered up and taken to, say, the San Diego Museum of Man, and then they'd be given a value? Like, because I heard someone say that Native Americans,
Again, similar to, not to cut you off, but similar to biological resources, noise, traffic, they're being analyzed.